Hello and welcome to Legal Basics with Sarah Global, and my name is Sian. Today, still on the intellectual property series, we're going to deal with a form of intellectual property that is confidential information. Contrary to popular belief, confidential information as a form of intellectual property is actually not new. It has been protected under several international instruments, including the Paris Convention that is as old as 1883. Now, for a business to have intellectual property in confidential information, as opposed to general confidences, it has to have some value that it gives to the business, and this value must be a commercial value. Now, confidential information could be pertaining to things that are very simple. It could be the database. It could be the criteria that the business uses. It could be the client information. All these things can be classified as confidential information. However, this is the threshold for a piece of information to qualify as confidential information as intellectual property. Number one, this confidential information must be generated through the mental effort of the owner or of the business. But this will also include people that have been contracted by the business to generate this kind of confidential information. Secondly, confidential information is protected as intellectual property if it gives the owner some commercial value. Now, information can be protected as confidential information, and it can also be protected under a copyright. Remember, in our previous broadcasts, we explained that copyrights do not need to be registered for them to exist. So, information, for example, a certain way that a business keeps its database can find protection under confidential information, and it can also find protection under a copyright. However, if the information is so novel, so unique that it amounts to an invention, then a person has to choose between confidential information and registration of a patent. Why? Because essentially, when a person registers a patent, they have to reveal all the details of their invention in exchange for having exclusive rights of exploitation of the invention. However, for confidential information, it is important that this information is not divulged to any other people, or it's not known to the public. However, sometimes for businesses to operate and to apply this confidential information to make profits, they are forced to divulge this information to other people. Sometimes these people are their employees, sometimes it is business partners, and sometimes it is in the course of consultancy. So how does a business protect itself from having their confidential information divulged to the public? Number one, always inform the person that is being revealed to that this information is confidential, and you have to tell them that they have a duty to confidentiality. Second, let the information be labeled. It could be in places that have restricted access. It could be in soft copy files that come with a password. It could also be unwritten, so long as it is communicated in a situation of trust, and it must be expressly labeled, or the person being told must be told that they have a duty to keep the information as confidential. Now, unlike other forms of intellectual property, confidential information can be protected even before it is infringed. So what does this mean? It means that a person who owns confidential information can move to court to stop another person from divulging that confidential information. So how does this happen? In that course of business where you have to share some of your confidential information with your employees, or with your partners, or with a fellow consultant, you have to have an NDA, which is a non-disclosure agreement. So usually that non-disclosure agreement will say what information should not be disclosed, and some employment agreements will stop their employees from working for competitors. So now, in the event, for example, that this employee leaves place A, where there was an NDA, a non-disclosure agreement, and wants to go and work at place B, which is a direct competitor of place A can go to court and stop this person from working for their competitor. However, when you do draft contracts that have a non-disclosure agreement, and especially where there's a restraint, where a person is not allowed to work for a competitor, you need to have your lawyers draft very, very carefully, because at the end of the day, the right of a person to earn a living will always supersede the right of a business to keep its secrets. So when you do draft your non-disclosure agreements, or when you do have any provisions that restrain a person from working for your competitors to protect confidential information, you have to be careful such that it does not overly restrict them to a point where application of that restriction would be unreasonable. Because at the end of the day, your employees, even after they leave your place of work, will have a right to earn a living. So, I hope this broadcast has been useful to you. If you have any kind of information that you feel gives you an edge in the market, you need to keep it safe. You need to ensure that your contracts contain non-disclosure clauses. You need to ensure that your information is labeled as confidential. You need to ensure that you have passwords, because if that time comes when you have to protect your intellectual property, you must prove as an owner of the confidential information that you have taken all reasonable steps to keep such information as confidential. I hope that this was useful to you. We will wait for your questions. Please write to us at saralowglobal@gmail.com. Bye-bye. Take care. Hello and welcome to Legal Basics with Sarah Law Global, and my name is Hian. Today, on part 2 of the Intellectual Property series, we're going to discuss copyrights. I'm sure most of us have seen the word copyright somewhere, in a textbook, in a storybook, in a movie, but do we understand what a copyright is? Now, a copyright is a form of intellectual property that protects the expression of original work or original ideas. Unlike other forms of intellectual property, it does not protect the idea, it only protects the expression. For example, if you went somewhere and you heard someone say a story, and then you stole aspects of that story and you retold it, this person would have a very big problem to prove that you stole aspects of your story from their story, because its expression has not been put in a tangible form. A tangible form would be in a song, in a recording, in written literature. Now, for copyrights, protection is not conferred by registration. A copyright exists the moment that an original idea has been expressed in a tangible form. So that means a person who is unregistered and a person who has registered a copyright of a pieces of work can both go after their protected rights of copyright. Now, unlike patents that require you to have novelty, a copyright does not need novelty. A copyright only requires that there be originality. Let me give an example. So you want to create a global song, and then you decide you want to have drums from South America, you want to have the flute from South Africa, you want to have a tune from North America, but you want to put all these things together into one song. So long as all these things together into that particular song has been your original work, then you can have copyright in that. As you can see, the drums and the flute and the sound and the tune are not novel things. They are things that have existed in the world, but the fact that you have put that expression together originally, that is what will give you a copyright. Now, different jurisdiction protects copyright for different length of time. For countries that are members of the WTO and a lot of Commonwealth countries, the term of protection for a copyright is the life of the maker plus 50 years. That is 50 years after their death. So unlike other forms of intellectual property, the property in a copyright continues to exist even after the inventor or the maker has already passed on to another life. Now, although copyrights do not necessarily need to be registered for them to be enforced, what are some of the advantages of registration of a copyright? First of all, when you do register a copyright, anybody else who claims that copyright would have to be the one to prove that you are not the original inventor. So it shifts the burden of proof from yourself to any other person that may be claiming copyright. Secondly, you are able to give licenses. A license, for instance, could be given by a person who is the original maker of a song to a company that wants to use that same song for advertising. If you do not have a registered copyright, then you would not have a legal creation with which you can give licensing. Thirdly, as the world is growing and increasingly recognizing intellectual property rights as forms of property, some financial institutions now are accepting intellectual property as a form of security for financing. So without registration, you basically will not have the title documents to your intellectual property, and registration will then enable you to be able to take some kind of financing against your property. I hope that today's broadcast has been useful to you. Please write to us at cyrolobglobal@gmail.com. We will be happy to hear from you. Protect your loved ones. Bye-bye. Hello and welcome to Legal Basics with Cyrolo Global, and my name is Sian. Today we're going to discuss a form of intellectual property that is little known and little understood, and that is geographical indications. You might have heard a few: Scotch whiskey, Kashmir apples, Darwad Pedan. What do these things have in common? The words and the symbols refer to products and their origin, where the origin influences the reputation, the quality, and the characteristics of the goods. Usually, geographical indications will be registered for tangible goods, because then the processes by which they are produced or manufactured can be regulated. Now, just like traditional knowledge, geographical indications is not a form of intellectual property that can be owned by individual. It is a communal right. Because it is a communal right, it cannot be sold and it cannot be transferred. However, when there's been an established geographical indications, some certain people can get user rights, which means they can use them to market their products. Now, geographical indications, just like traditional knowledge again, is not conferred by registration, which means people or groups of people or communities can enforce their rights when the GI or the geographical indication is registered and when it's not registered. However, when the geographical indications have not been registered, then the owners or the people that claim to own it cannot go after people that infringe their geographical indications. Now, there could be certain reasons why a geographical indication is not registered. Number one, if the geographical indication is confusing, if it refers to a place that is not definite, or maybe different places have the same name, then it will not be registered. Secondly, geographical indications will not be registered when they are contrary to any moral code of a community, if they are contrary to morality. Third, geographical indications will classically not be registered if they are likely to offend the religious beliefs of any community. Now, for any kind of word or symbol to qualify as geographical indications, it must have two qualities. Number one, it must link the goods to where they come from. It must be their true origin. Now, goods that come from place A must bear the name of place A. Secondly, the origin must essentially influence aspects of characteristics of that good. It could be the environment, it could be the technique, but the fact that the goods come from that place, it must influence their quality. Now, when geographical indications have been registered, what are some of the advantages? First, when it is registered, the owners, the group of people, the community, the association of producers, they get to build their brand. So that means the goods that are associated with that region are going to be able to build their brand in the market, and this leads to economic prosperity. Now, geographical indications are not trademarks. Although they are used to distinguish goods, they are not trademarks and they are not protected under the law of trademarks. However, unlike traditional knowledge, registered geographical indications are not indefinite in terms of term. Geographical indications will last specific periods depending with the law of the specific countries. In most Commonwealth countries and the countries that are members of the WTO, geographical indications will be protected for a term of 10 years that is renewable. Now, I hope armed with this information, you can look around your area and see what you can do for your community. What is special about things that are produced in your locality that we cannot find anywhere else in the world, such that if you were to protect that name and link it to your origin, it would be able to make your goods stand out in the market. I hope that this broadcast has been useful to you. Please write to us with your queries at saralogglobal@gmail.com and we will be sure to answer your questions. Hello and welcome to Legal Basics with Sarah Global, and my name is Sian. Today we discuss a form of intellectual property, which is industrial designs. Let's start with an example. If you found a bottle of Fanta without the writing that says it is Fanta, would you know that it is Fanta? I would. And do you know how I would know that it is Fanta? Because of the shape, because it is unique, because no other drink comes in a Fanta looking bottle or a Coca-Cola looking bottle or a Sprite looking bottle. Now, industrial designs refer to the shape, configuration, or ornamental aspects of three-dimensional objects. Just like patents, industrial designs have to be novel and they have to meet the requirement for industrial application for them to be protected. Other than that, industrial designs have to be appealing to the eyes and they have to be unique, such that it distinguishes the products from others in the same industry. Now, industrial designs in Kenya can only be protected for 2 terms of 5 years each. The first term of 5 years, which is renewable for another term of 5 years. After the lapse of 10 years, industrial designs can no longer be protected. Now, industrial designs cannot be about aspects that are protected under trademark, and it cannot be aspects that are protected under copyright. So before you decide to protect a shape or a configuration or a pattern or a form of a product for it to be distinguishable in the market, you have to ensure that the aspect that you want to protect is not protected under copyright, and you have to ensure that it's not protected as a trademark. I hope this broadcast has been useful to you. Please write to us with your questions at saralogglobal@gmail.com. We will be happy to answer you. Take care of yourself and stay safe. Bye-bye. Hello and welcome to Legal Basics with Sarah Global, and my name is Sian. We are still on the intellectual property series, and today we're going to compare the pros and cons, the advantages and disadvantages of protecting ideas either as confidential information or as patents. Remember, when we discussed patents, we explained that for patents, the inventor exchanges, reveals his original ideas in exchange for the rights of exclusive use of those ideas. So basically, the patent regime says, give me your ideas, reveal them to me, show me your processes, how you make your product, how you arrive at this thing that you're making. Tell me everything. In exchange of you telling me, I am going to ensure that nobody else makes what you make unless you allow them. That is a patent. For confidential information, we say, don't tell me. If you tell anyone, give them a non-disclosure agreement such that your information is safe. So now, as a person with original ideas or as a business, how do you go? Do you protect them as confidential information or do you protect them under a patent? So on today's episode, we will consider which one is better than the other. So number one, the first thing that you need to consider is whether your ideas are patentable. Now, you may have ideas that are very unique in your place of business. You may have ideas that are very unique in your country. However, you might not be sure whether somewhere else in the world, somebody else has registered that idea as a patent. Now, for patents, as we said, your idea must have three main ingredients. It must be completely new. Nobody has registered a patent in that name. It must have an inventive step, which means it's not obvious, and it must have industrial application. However, for confidential information, it could be over ideas that are patentable and the ones that are not patentable. So if you're not sure whether your idea meets the threshold for a patent, then you might be safer protecting it as confidential information. Secondly, you need to understand the patent law in your country or in your jurisdiction. Jurisdictions are different. Some jurisdictions allow you to put your ideas to use and even demonstrate them or reveal them once you have filed an application for patent. Some jurisdictions do not allow you to reveal this information at all until your application has gone through and your patent has been registered. So, depending with the jurisdiction or the country where you want to register your patent, you're going to look at the threshold for revealing your ideas. Is it the application of a patent, the fact that you have filed, or is it the fact that you have already been registered? If you exist in a regime that does not allow you to use these ideas or demonstrate them before you have gotten a full registration for a patent, then you're safer protecting them as confidential information until you decide that you want to now get a patent and then reveal them. Third, you need to look at the strength of protection. Now, a patent gives you very strong protection for 20 years. So, when you take a patent and you register it, it means that nobody else can register a patent over your idea. Whether this person sat in another continent and had exactly the same idea as you, the fact that you have registered your patent stops this person from using that idea or that process. So the protection is extremely strong. Even if somebody mistakenly or accidentally or independently came by your idea, the fact that you have registered stops them from applying your idea except with your express authorization. However, for confidential information, you could keep your ideas as secret as possible. However, if somebody else comes by the same idea independently through reverse engineering or through discovery, then your secret is out and you cannot go and stop them from applying that idea. So depending on the strength of your ideas, now when you go the patent way, you get stronger protection. When you go the confidential information way, you get weaker protection because it allows somebody else to apply that idea. Fourth, you need to look at the term of protection. For a patent, your ideas and the fact that you can only exclusively use them, or somebody who has been given an express consent by you for patents, you can only use the patent for 20 years. After 20 years, other people are allowed to apply your ideas. However, for confidential information, so long as the secret never gets out of the hat, you can protect it forever, so long as you keep it secret. So depending with how much longer you need your idea to be protected, then confidential information will ultimately give you a longer period of protection than a patent, because a patent will expire after 20 years. Lastly, and number 5, you need to do a cost-benefit analysis. So for confidential information, you will look at how much your business or you as a person or your resources allow you to protect that information and keep it confidential. Now for a patent, you will have to look at the money or the cost of hiring patent attorneys, of making an application, of paying for examination, and maybe if there's objections. And then once you compare the cost, you're able to see which is better for you and better for your business. I hope that this broadcast has been useful to you. Please write to us with your queries at cyrologlobal@gmail.com. Please, if you like this video, like, subscribe, and share with your family and friends. We are hoping that at the end of this intellectual property series, you will be able to all come up with wonderful ideas and you will be able to protect them, because intellect is property. Bye-bye. Take care of your family. Stay blessed. Hello and welcome to Legal Basics with Sarah Law Global, and my name is Sian. Last week we wrapped up the series on the law of business associations. If there's any topic that you would like us to cover in that series that we have not covered, please write to us at cyrologlobal@gmail.com and we'll be able to do a broadcast on the topic that you would like. Now today we are on to a different topic, which is intellectual property. What is intellectual property? This is the product of our mind, our intellect. It includes our ideas, our imagination. Now, specifically today, we're going to deal with a form of intellectual property called patent or patent, depending on where you went to nursery school. So what is a patent? A patent is a form of intellectual property that gives a creator or an inventor exclusive rights over their ideas in the process or product. Now, a patent only lasts for 20 years in Kenya and most of the jurisdictions. Countries that are members of the World Trade Organization protect patents for a minimum of 20 years. However, it could be more depending on the country. But for Kenya and for other Commonwealth countries, the term of protection for a patent is 20 years. Now, before a person or a business registers a patent, you need to ask yourself very important questions. One of them is, do you have the means to turn that idea into money or into profit within 20 years? Because after 20 years, the term of a patent is not renewable. So if you do not have the means to turn this idea into profits for yourself, then you might want to keep it until you're ready. So that's one of the very fundamental questions that individuals or businesses must ask themselves before the registration of a patent. Now, how do you know whether an idea qualifies to be protected as a patent? Number one, it must be novel or new. This means that it must be an idea that has not been patented anywhere in the world and an idea that is not out there. People do not know about it. Secondly, it must meet the threshold of usefulness. You see, there's some good ideas in the world, but some of them may not be useful. If it fails the usefulness test, then it cannot be patentable. Third, an idea must have an inventive step. This means that it should not be obvious for any professional that practices within that field or any expert. It is not something that an expert in that field would come by or apply. And fourth, it must have industrial application. You need to know that business ideas that are not industrially applicable or adaptable cannot be patented. Now, objects and processes that are patentable also can be different between different countries, and you have to look at the specific laws in your country to know what is patentable and what is not. However, generally, some things are not patentable. One of them is business processes. Secondly, mathematical and scientific formulas. And third, methods that are used to treat human beings and animals cannot be patented. Remember that a patent keeps all other people except the registered user from the use, from the manufacture, and from the selling of that idea, such that only the user, only the inventor, or the people that have been licensed by the inventor can apply that idea. Now, as far as territory goes, a patent can be registered in a nation, it can be registered in a region, and it can be registered in an international organization. What is the effect of registration of a patent? When you register a patent in your country, it means that you can go after anybody who infringes that right, who infringes that patent. However, when you register in a country, it still means that somebody else in another country can never patent your idea. So, before you patent an idea, you must carry out a global search. So basically, when a person has registered a patent, it means that it is the only idea in the whole world. There is no other one like that one. However, the protection will only depend with the regime that they have chosen to register under. So if you registered in your nation, it means you can only protect yourself against infringement in that nation. If you've registered at a regional level, you're going to get protection within that region or in the countries that are members of that organization, for example, ARIPO. And then if you protected at a global level, you're going to get protection at that global level. Still, when you register, a person can never register a patent of the same idea, irrespective of the regime under which you have registered. I hope that this broadcast has been useful to you. Please write to us with your questions, cyrologlobal@gmail.com. Stay safe and take care of your family. Hello and welcome to Legal Basics with Cyra Global, and my name is Sian. Now, a while back, I saw a meme on Facebook that said, I have lost my job at KFC and now I'm going to tell all of you what the recipe is. It's garlic and cardamom and cinnamon and salt and something else. I don't remember all the spices, but it was very funny. Anyway, I hope it was not true, because if this person did reveal the secret ingredient to KFC, he would be sued for a lot of money. So now, what is that? That thing that he was trying to reveal. That is called a trade secret. Now, a trade secret is a form of confidential information, but it is unique. So it must meet the threshold of regular confidential information as a form of intellectual property, and it must have its own extra qualities. Now, what are some of the trade secrets that we know? One is the secret ingredient in Coca-Cola. People talk about it a lot. They say only 2 people in the entire world know what that secret ingredient is. There is the algorithm for Google search. There is the criteria that New York Times decides on which is their best seller for every period. So many companies that thrive have a trade secret. So just like all other forms of intellectual property, a trade secret must be unknown in the market. It must be through the intellectual work of the owner or somebody contracted by the owner. There must be some kind of protection, and it can be protected even before infringement has happened. However, above the other forms of confidential information, certain unique features attached to trade secrets. First of all, for a secret to be a trade secret, it can only be revealed on a need-to-know basis. Now, that, for example, means that if a person works for your company or is in partnership with you or you're consulting, and in the course of that trade or that relationship, this person does not really need information to perform their task or their responsibility, then you should not reveal. As opposed to all other kinds of confidential information where you can reveal, and just so long as you tell this person that they're not supposed to reveal it or that they're bound by a duty of confidentiality, for trade secrets, you should only reveal on a need-to-know basis. So that basically means that if I have a secret ingredient in my cake and I need my assistant to know how to bake that cake, I can tell her. But the person at the reception has no business knowing. So if the person at the reception gets to know, then it means that I was not able to sufficiently protect my trade secret. Secondly, although all forms of confidential information should have some commercial value, for trade secrets, it must have an independent economic value. So basically that means on its own, that secret would be able to be a game changer. And third, as much as confidential information regards all things that makes a business prosperous, for trade secrets, the secret must be giving the business competitive advantage. It must be the one thing or the 2 things or the 3 things that make this business to be ahead of the others. As a form of intellectual property, it attracts a lot of arguments, and one of the arguments is that protection of trade secrets allows businesses and persons to maybe use things that might be harmful to others and the others have no way of knowing. For example, we don't know what is in Coca-Cola, right? We don't know whether it harms our bodies. We don't know whether if they were to reveal it, then we would not drink Coca-Cola anymore. We don't know what's in that KFC chicken. We don't know whether that's why me and you keep going back to KFC. We don't know whether it's addictive. So for trade secrets, before you decide to protect them, you have to think about the moral values. Now, for trade secrets, they do not have to be registered to be enforceable. You do not even have to say that my company uses a secret that we do not tell people. You can keep it to yourself if you want to. However, if a trade secret has been revealed to a person in the course of business, you get to restrain that person from sharing your trade secret with a competitor or with another person in your industry. So just like all other forms of confidential information, people whose who trade secrets have been revealed to can be restrained from sharing their trade secrets through non-disclosure agreements, and also their independence to be employed by anyone can be curtailed by a non-disclosure agreement where they are restrained from working for competitors. Now, I hope that this broadcast has been useful to you. If you have any questions, if you need us to do any more broadcasts on this topic, please write to us at cyrillawglobal@gmail.com. Keep safe, sanitize, and protect your families. Bye-bye. Hello and welcome to Legal Basics with Cyril Law Global, and my name is Sian. Today we're going to talk about a form of intellectual property that is probably the most well-known, and that is trademarks. Think about it. Facebook, IBM, Google, Sprite, Standard Chartered Bank, the Olympics. When these words come up, an image forms in your head, a color, a sign, a picture, a drawing. So generally, trademarks are words, expressions, or signs that are recognizable and that distinguish products and services and connect them with their source and their producers. What are some of the advantages of registering a trademark, either for an individual or for a person in business, or for a business itself or a company? Number one, when you register a trademark, it keeps all other people from using your registered trademark. So when somebody else uses the mark or the color combination of the expression, then you have a right to sue them for infringement of trademark. Secondly, because a trademark distinguishes your products from those of your competitors and other players in your industry, it helps you to build your brand. Building a brand takes work, it takes research, it takes investment, it takes hiring the most talented people for your products and services to be the best. After all that investment, it would be very bad for a business if somebody else would be able to trade under that name. So when you do have a trademark, you protect your investment in the quality and in all the things that have gone into making your product the best in your industry. Thirdly, when you have registered a trademark, you have a right to stop other people from confusing. For example, if your trademark is certain colors or certain words or certain names or certain pictures or drawings, and another competitor uses words that or expressions or pictures that are similar to yours, then you do have a right to sue them so that they can stop using that and stop confusing customers who would otherwise have preferred your products. Now, the term of a trademark is 10 years in Kenya, and it is a minimum of 10 years for most of the countries that are members of the World Trade Organization and for most Commonwealth countries. Unlike other forms of intellectual property, a trademark can be renewed indefinitely. So that means when you pay for your protection within that 10 years, after that 10 years lapses, you can renew it for another 10 years. When it lapses, you can renew it for another 10 years. When it lapses, you can renew it for another 10 years. Now, when you're inside the bracket of registration, if your registration has not lapsed or it has not expired or it has not been cancelled, what are some of the protections that you enjoy? One is that nobody else can use your trademark, nobody can ride on it, nobody can have similar looking products, and it helps to take out the counterfeit and set them apart from your original products. Now, for people or businesses that have been having a trademark for a while, but the trademark has expired, they will still get some kind of protection if the trademark has been so well known such that another person cannot register that trademark. Now, generally, if you're not so well known, if you go to, for example, if you go to register a trademark on Coca-Cola in a country where Coca-Cola has not registered a trademark, chances are it will still not be available to you because that trademark is already very well known. So there's two reasons why you would not be allowed to register a trademark. One is if there's an existing mark that is very similar to what you want to register, and two, if there is a mark that has not been registered but still it's out there and it is known, you will not be allowed to register a trademark. Now, as businesses grow, when you're starting out your business, maybe your bakery, you bake some wonderful cookies, at the beginning, the value of a trademark may not look very important to a business. However, as the business grows and it builds clientele and becomes known, it becomes more and more important to protect that name and protect that brand. And the best thing about a trademark is that, considering how much value and how well known it is and how people like it, with time it becomes valuable. And some companies have been able to sell a certain trademark just like any other kind of property. So it is important for individuals in business to consider protecting their trademarks from the word go, because as the business grows, you are also building a name, and with time that name in itself, or that mark, or that expression, can be exchanged for money's worth. Hello and welcome to Legal Basics with Sarah Global, and my name is Sian. Now, for those of you who have been to Nairobi, maybe from other countries, I'm sorry, I'm going to market my capital city. As you walk around on the street, sometimes you see people in different paraphernalia. We call it a shuka, sometimes carrying some gallons of colored liquid. And we know that you take them, and I know what you take them for. Anyway, now the liquid in those gallons is an art that has been passed down from generation to generation. This person that you buy herbs from, or whatever liquid it is, he did not go to school. He does not have a medical degree, but they can give you something for your flu, something for your headache, and something for those other problems that we will not say in this video. Yeah? That is example 1. Example 2. Today I am representing my community, and what I'm wearing on my neck, this is made by people from my community. We use beadwork. However, one day, somebody in Gucci or Versace, somewhere in Milan or in Paris, they may decide that that year they're going to use beads to make clothing or to make jewelry, and then they will sell them to celebrities. And I will sit in my country and complain that this person has. So, what happens? Now, that what I have described is a form of intellectual property that is known as traditional knowledge. What is traditional knowledge? Traditional knowledge is living, breathing body of knowledge that has been developed and sustained by indigenous and local communities, and it has been passed down from generation to generation. Now, traditional knowledge can be embodied in tangible and intangible forms. For example, it could be in the methods of agriculture, it could be in the methods of treatment, it could be in ingredients and herbs and barks and ways of making medicine. It could also be in handicrafts. Now, it can also be in intangible forms. It could be in forms of music or poetry or folklore. You know, some stories belong to specific communities, and people can listen and go out there and publish them and make money from them. Now, traditional knowledge is protected in some places in the world and not protected in some places. However, traditional knowledge is recognized the world over. The World the World Intellectual Property Organization, once they find that there is sufficient proof that a certain knowledge or way of doing things has been traditionally done for generations in a certain community, then they are able to enforce that right. Now, countries like India have been able to come up with a database of their own traditional knowledge. And this has included their genetic material, it has included their herbs, their forms of treatment. Now, India has been able to have 2 patents in the United States cancelled. One patent was in the year 1971 that was registered where neem products were used to make pesticides. Another patent was in the year 1995 where turmeric powder was used to make a drug that was used to heal wounds. The argument was that back in India, neem and turmeric products have been used for generations and generations. So that way, somebody cannot use those products and come back and claim that they have made an invention. Now, what makes traditional knowledge not be preserved or not be sufficiently protected? The first thing is that your community uses different words that are probably not the words that are used in the mainstream media or in the rest of the world. Now, a hub can have a different name in your community or in your local language, but in the big arena, nobody knows about that word. So that way, when somebody wants to register a patent and they carry out a search, they have no way of knowing that actually your community has been using that specific herb because you use a different word. What are some of the benefits of protecting traditional knowledge for your community? First of all, it protects the community from having their ideas stolen and patented or protected in any other way such that it will keep this community from benefiting. Secondly, it enables you to take part in the benefit sharing when these ideas have been used to make money or when they have been commercialized. Like if I go back to the example of my necklace that has been used with the traditional knowledge of my community, if today Versace wanted to incorporate this idea into their garments, we can easily, me and my community can sit with Versace and say, no problem, you can make something from our idea, but when you do make the profits from it, we want 50%. We can also negotiate employment opportunities because our people will come with their own traditional knowledge and help them to create the same things that we have been creating year in, year out. I hope with this, armed with this information, you can go back and empower your community. Empower them. Find a way to protect their ideas, and you have to start with documentation. When you go to the village, sit with your grandfather and his friend and your other neighbors. Get to know how people did things in the past, how they cooked their food, how they told their stories, how they made their garments. After that, document it, because the moment that you document, this will be the proof that traditional knowledge has been existing in that community for generations. And also stay alert so that anytime the ideas from your community have been applied in the bigger scenario, then you can go there and claim your right. Most importantly, ensure that by preservation of traditional knowledge, communities have been empowered to make money and improve their lifestyle. I hope this broadcast has been useful to you. Please write to us with your queries at saralowglobal@gmail.com and we'll be happy to answer your questions. Sanitize, stay safe. Bye-bye.